Good morning, counsel.
Good morning, Your Honors. Kevin Nixon for Ms. Berry.
Okay. Start again. The light just went on, that's why.
May it please the court, Kevin Nixon for Ms. Berry. Your Honors, this case warrants your use of 33E to reach a result here that's more consonant with justice than life imprisonment without any possibility of parole. This is the second time the case has been here, and I know that you're well familiar with the facts. It's a tragic, sad, even horrifying case, and it warrants the use of 33E to reduce it to something that at some point in the future will permit Ms. Berry to leave prison. She was 26 years old when this killing occurred in 2002. She's been in custody, of course, ever since. She's been through 2 trials, convicted of first degree by reason of extreme atrocity or cruelty in both. And I can tell you that she remains mentally ill. Her several delusions that appeared in her testimony and in her medical records, which were also entered in evidence, remain fixed. But the aggressiveness, the assaultiveness, and the irrational, overwhelming anger that led to the commission of this killing were removed from Ms. Berry when they removed the tumor that they found had been growing in her brain since the late 90s. They removed it, of course, in 2003. After that, her behavior changed markedly. She became compliant. The people at Taunton, who were, of course, in charge of her care, decided to remove even the guardianship that they had obtained regarding her treatment and medications, and allowed her to make...
After all that, did she testify at both trials or just the second trial?
Well, at the second trial, the Commonwealth placed the transcript of her testimony from the first trial.
Basically, she denied doing it.
She denied doing it and explained that, in fact, her girlfriends had done it while she had called 911. In reference...
So she did not testify in the second trial?
She did not testify at the second trial. There was a colloquy regarding her decision not to testify at the second trial, and during that colloquy, I think it was actually her attorney who asked Mrs. Berry, if you did testify, Ms. Berry, would you say the same things that you said at the first trial? And her response is absolutely. She would testify exactly the same way. And having Ms. Berry for a client made it, I'd suggest, impossible after even reversal and remand to try to broker a plea bargain in the case. You have a client who is not going to acknowledge that they did anything wrong. She's suffering this delusion. Is as deeply in her and as fixed as the several other delusions that appeared during her testimony. Now, I think it's worth noting that the jury was instructed on both deliberate premeditation and extreme atrocity or cruelty. They did not convict on deliberate premeditation and did convict, of course, on extreme atrocity or cruelty. And as I was preparing for today's argument...
was that true in both trials? I don't remember in the first one.
Yes, it was, yes. And as I was preparing for today's argument, I remembered the court's 2011 decision, Commonwealth versus Rutkowski, which was a first-degree case involving extreme atrocity or cruelty. And the court actually, I think it was reversed or reduced to second degree when the judge in that case had failed to instruct, even to the extent required by the 1999 model instructions, that extreme atrocity, that the jury should be aware that mental impairment is a factor that they should take into account even when reaching a decision regarding extreme atrocity. But the thing that was of interest to me then, when I read the case in 2011 and saw it again a few days ago, is where the court explains, quote, intent and knowledge are not aspects of extreme atrocity or cruelty. And, you know, I hadn't really thought of that until I'd read that case in 2011. There's a footnote that is dropped from that piece of the text that explains in greater detail how that is true in extreme atrocity. Intent and knowledge are not aspects of extreme atrocity or cruelty. So, you know, Ms. Berry had a criminal irresponsibility defense. She also had a mental impairment defense that went along with that. But, I mean, you have a very hard row to hoe to obtain any sort of relief under a mental impairment defense when you're standing trial for extreme atrocity or cruelty, where intent and knowledge are not aspects of that offense. It's basically, that offense cannot be affected by proof as compelling as Ms. Berry's was regarding mental impairment, to the extent that that could mitigate a first-degree conviction by reason of extreme atrocity to second degree, or even manslaughter, because, I mean, given Ms. Berry's severe mental impairment here, I think there's substantial doubt whether this killing was committed even with malice. So, as I mentioned earlier, the judge at the Rutkowski trial, that case was reversed because the judge did not even say the little bit that's required by the model instructions about the applicability of mental impairment to your consideration, jurors, of whether or not the offense was committed with extreme atrocity or cruelty. This judge did do that, but she didn't do anything more than that, just reference that. And defense counsel didn't ask for anything more than that. There are alternate formulations that communicate, I think, in greater explanatory detail what's merely adverted to in the model instructions. And these alternate formulations appear in cases like Rutkowski and Gould and Richard Rosenthal, where the court describing this concept says, quote, consider that the jury should consider what effect the defendant's impaired capacity had on her ability to appreciate the consequences of her choices. Or, in other cases, that mental impairment of a defendant's ability to make a decision in a normal manner may have a direct bearing on the degree of murder and consequently on the issue of extreme atrocity or cruelty. Now, I can't say that these more expansive definitions of the same concept that is merely adverted to in the model instructions would have made a difference at Ms. Berry's trial, but I think her trial would have been a fairer one had the jury heard that, given this sort of special circumstances that her condition brought to their consideration.
I don't remember this, do the current version of the model instructions adopt any of this?
No, they repeat the language that was in the 1999 version. And the problem that you see in a lot of these cases, this one included, is that this kind of gets buried somewhere between the definition of deliberate premeditation and second-degree murder, and then extreme atrocity comes last, with the three prongs of malice being applicable to extreme atrocity, and it's never referenced again. Now, the jurors here had, you know, a paper copy of the judge's instructions.
Extreme atrocity came last, after second degree?
Yes. Yes. I believe that's the case, Your Honor.
That's weird.
I looked at this yesterday.
Okay.
And I think that the judge, I think she does that as a way of introducing the three prongs of malice, which are now going to be sufficient to satisfy extreme atrocity. But the mention of the effect of intoxication or mental impairment gets put between premeditation, after premeditation, and before second degree, and extreme atrocity. And I can't say that, you know, the jury wouldn't, especially with a paper copy in the room, go back and look at it and check it in a way that they wouldn't if these instructions were only delivered orally. But I think there is a more fair way to do it, which is to use the larger, more expansive explanations of this concept that are provided in the case law. So there's one legal error that's been raised in the brief, in addition to the request for justice under 33E from Ms. Berry, and it has to do with the judge's refusal to strike Dr. Murphy's expert opinion. And
it's your position that it, in the form of opinion, basically misinstructs on what doesn't follow the de Padova
yes,
articulation. Is that right?
He has an opinion, which is that she was criminally responsible. And then, as you...
And that her capacity not to conform was the result of substance abuse and not mental.
Yes, that's correct, Your Honor.
That was his direct testimony.
That's his testimony. And on direct, and then it's tested on cross for the source of his opinion in that respect is tested on cross. And he says essentially that if she's responsible for her drinking, then she's responsible for everything that came after drinking. And that is simply is an inaccurate, totally wrong description of the law that, regulates the jury's decision-making in this area. And the judge, she should have struck it, I think, because it's, imagine if this is an exaggeration, so please bear with me, but, you call a Dr. Nixon, and Dr. Nixon says, I have an opinion, she's criminally responsible. And then on cross-examination, we probe the source of that opinion. Well, I cast her horoscope and saw that, Jupiter was aligned with Mars, and, oh, well, I'm not going to, it's in for what it's worth, and you can, the jury will just sort it out, and you can demolish that in your closing argument. It wasn't really dealt with effectively in closing argument. It was just sort of left to one side it was disparaged as an opinion that did not deserve serious consideration, but it wasn't really taken apart as inconsistent with the law in a way that would have helped the jury disregard it to the extent that it deserved to be disregarded. So that's my position on the one legal error that I was able to comb from the transcript here. That it should have been struck because it was unhelpful, it was confusing, it was even irrelevant. And
now, Dr. Murphy wasn't just a doctor from outer space. He actually had examined the defendant on many occasions. Was he a treating therapist for her?
He's a forensic therapist at Taunton State Hospital. I'm not really sure how much treatment he afforded. He reached his opinion regarding that she was not
competent,
that she was not irresponsible.
Well, he did a number of opinions throughout this period of time.
Yes. And
competent, didn't he do a competency evaluation?
He did a competency evaluation. He found her incompetent several times, and then the responsibility opinion was reached at a. She had her surgery for the tumor in April of 2003. I think it was in March or February, 1 or 2 months before that he writes his opinion, concluding that she is criminally responsible, and there you go. So here's a person that, by all other accounts, during that period before the surgery was conducted, was completely out of control, even while medicated, and spent a lot of time at Taunton during that period in 4-point restraints.
There was another doctor who testified that she was criminally responsible as well.
Dr. Vasily.
Yes.
His testimony is interesting to the extent that it almost, he of course reaches the opinion that she is not that she is criminally responsible, right. But his opinion in its particulars actually lends some support to the conclusion that she was not criminally responsible, because if you look at what he has to say in light of what the court had to say in Berry and de Padova about what the law says about these matters, his opinion, the basis of his opinion, could be used by the defense to argue that, in fact, he's concluded. If you just look at what the facts are that underwrite his opinion. For instance, he says that she has this long-standing mental illness, there's no doubt about that, and that when she pours liquor on top of that, she goes, I think he says, off the top.
Right. Over
Yeah,
the top.
over the top. And, I mean, that's
That's sort of straight out
that's a
of.
pretty decent claim of criminal irresponsibility under the law. So, of course, he reaches a different conclusion, but the particulars underlying that conclusion themselves tend to support a finding of criminal irresponsibility. Now, of course, the two juries have rejected that and have found that she was criminally responsible. And I think that if the case, went to trial again, they probably would reject it again, honestly, because once you see Exhibit 21, which is a photograph of this poor man, Mr. Gonsalves, you see that picture taken on the autopsy table before he was cleaned up for the autopsy. I mean, you don't really need to hear any more evidence because the prejudice, and I'm not saying it's unfair prejudice, but prejudice that flows from that photograph is really overwhelming. So what I'm asking for the court to do is use your 33E power to reduce this to second-degree murder or manslaughter, because Ms. Berry, serving a sentence of life imprisonment without parole ever, is not consonant with justice.
All right, thank you, sir.
Thank you, Your Honor.
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, whether or not at the time of the killing the defendant was criminally responsible was thoroughly disputed issue in the case. There was evidence going both ways presented to the jury. As my brother's last couple of points just suggest that there was evidence from each of the doctors that supported either one of the conclusions. Dr. Vasily gave some support for either basis for the conclusion. They all agreed there was a mental disease defect. Some of the defendants' experts said things like there was no indication of any kind of delusions or psychosis at the time of the killing. The evidence in some was thoroughly disputed and presented to the jury. It was thoroughly divided. It was for the jury then to take the evidence as presented to them and decide what the appropriate conclusion here. My brother is asking you to reduce the verdict here, but he basically just conceded that if you looked at the nature of the killing, there's really no question that as long as she was criminally responsible, this killing was extremely cruel and atrocious because of the disparity of the amount of force used and any force used in the killing.
Mr. Thompson, setting aside the conflicting expert testimony of the 5 witnesses, expert witnesses, what other evidence was there of competence or criminal responsibility?
The evidence was that there was evidence, first of all, there was no indication of any kind of delusional thought process or any kind of psychotic thinking in her actions or thoughts or descriptions at the time there. The fact that she, in fact, gave an exculpatory version is not particularly indicative of any kind of insanity more than anybody else who tries to excuse their criminal conduct, Your Honors. In fact, her exculpatory version that she didn't even do it is rational, is coherent, and provides a motive for the murder by these other people.
Rational in the state of the evidence?
Your Honors, because there is, what's the state of the evidence? The state of the evidence is essentially these 2 other women who say that she did it, and she's saying that they're fabricating
How about
it.
that the victim was the one who years or months ago bound her up and raped her? That's rational?
Your Honor, that's not every aspect. My brother is suggesting that merely because she claimed that she didn't do it, then that's an indication of insanity. That's all I'm
That's
focusing
not what
on
his
there.
claim. That's not his whole argument.
That's not his whole argument by any means. There were aspects, there's no question that at points in her life, she exhibited delusional psychotic thinking. The point I'm making is the mere fact of possession of a mental disease or disorder is not enough. No one disputed that she had that. There has to be a causative relationship between the mental disease and disorder and the killing. Here, as I said, there's no indication of psychosis or delusional thought. That thing, what you just described, Ramona, came much later on in her descriptions of the events. It was not anything that came up on the night of the killing, Your Honor. And there's no witnesses to that whatsoever that said anything like that. What happened on the night of the killing was there was an argument between her. She resented the fact that, from the witnesses, she resented the fact that he had laid his hands on her and she was mad. The indication that she was able to
The other guy. Are you saying Gonsalves or the other guy? I forget
he
his name.
laid the victim here, not the other guy, Gonsalves, laid her hands on him. As the witnesses described, when they came out of the house, he was holding her up against the house. He was holding her up against the house, and he then supposedly broke off, and that's when he turned into Deanna, said, I don't mean to disrespect the house. But before that, whatever happened between them happened, the argument outside, and he ended up holding her forcefully up against the house. She said she resented him laying his hands on her. She demonstrated her ability to control her conduct, to conform her behavior by backing off when Deanna asked her to back off, by stepping away, by standing there and acting calmly. As she had, through many of the descriptions of the other witness, every time they had seen her get angry before. She got angry, yes, but she did not lack control of her conduct. Here, she demonstrated that control by acting, as a number of witnesses agreed, even some of the defense witnesses, in a goal-oriented, purposeful fashion. First, she stopped and controlled behavior as she tried to take a chance to explain why she was so angry to Deanna and her friends. Then, as things began to escalate, as the other friends of the victim arrived, the witnesses described how it began to escalate again, tempers began to rise again. Then she went into the backyard, obtained a weapon that would fit what she wanted to do, and came forward and struck not randomly away, but struck at her intended victim, reaching over one of the women in the house to get at him.
And how much time passed between his touching of her and her beating him over the head with the cinder block?
I don't know. I can't tell you now that it was a specific period of time. It was enough for a substantial period of conversation to go back and forth, for the car to drive up, for some more conversation to occur, for a period of time in which, as I've said, as a number of the experts also agreed, that she acted in a goal-oriented, purposeful fashion, inferably, therefore, in a fashion that showed her ability to control her conduct and conform her actions to the
And did the
requirements of the
defendant
law.
argue that his touching of her was provocation that justified manslaughter? Was that argued?
No, never.
It was not
Never
argued to the
hinted at
jury.
it, no. And there was no indication that there was any such sudden assault that would be some surprise or it was sudden combat. That was never raised in any fashion whatsoever, Your Honor.
Do we know how many times she struck the victim with the cinder block? I know there were 18 pieces or something like that.
I know
but
that
does
it was
mean
numerous
18
times. I know it was enough that the cinder block broke in her hands and crumbled into little pieces. It was over and over again. I don't know if there was ever a specific number of blows. It was a substantial number of blows.
Was the jury given a manslaughter instruction?
No, they weren't, Your Honor, and none was requested.
Can I just go back, just to clarify, because I mentioned earlier about the implausibility of a defense, perhaps. And you said, well, but the only people were the ones she's accusing. It is a little unclear, so if you could clarify for me, what happened to all the people in the car who were there speaking to the victim and then moved away and then came back? Were they not?
No, you're right. The police in the car didn't have much to say. They just said that she ran up and hit him, and then they drove away.
Oh, they did see it.
You're right. They're there as well.
Okay.
They're there as well. That's absolutely correct, Your Honor.
Witnesses.
What?
Got a lot of witnesses.
There's
There's a
one
car-
person from the car testified to that.
Were there others in the car? There was a car full
I
of people.
believe there was
Right.
several people in the car.
But there could have been more, but you picked.
They weren't, for one reason or another, who knows, they weren't called, you know. The point, Your Honor, is that whether or not this court would have arrived at the same decision as the jury did, this is a jury system we work in, and this is a situation where there really is no reason to take this fully disputed issue away from the jury. There's particularly no reason, I mean, this court has never reduced a first-degree murder based on criminal responsibility issues when there has been affirmative evidence of criminal responsibility presented to the jury, as there was here.
In Colleran, there was none?
In Colleran, there was none, and there was also, that's a situation where this court reduced it, and I was about to mention it, because in Colleran, it was a situation where the mother, for no apparent reason, pushed her child's face against the sofa, cutting it off, in a situation that this court saw as beyond what would be normally considered cruel and unusual in the nature of the killing. That scenario is certainly not present here with the bashing somebody's head with a cinder block numerous and numerous times. As my brother suggested here, that scenario, the idea that it's cruel and unusual is almost inescapable, Your Honor. And there's no justification for reducing it to second on those grounds whatsoever, nor any justification for a new trial, because because it was fairly presented to the jury, and the jury decided it. If the jury feels that they want to take a stricter view on criminal responsibility on particular facts than this court would, it's within their province, and they should be allowed to do so, Your Honor.
Did Dr. Murphy mischaracterize the law in his opinion?
I don't believe so, Your Honor. Dr. Murphy never suggested, never indicated, never adopted the defense counsel's suggestion that consumption of some kind of intoxicant could nullify any kind of criminal responsibility defense. He just simply did not say that. He said, to the extent that someone's capacity is lowered by voluntary intoxication, then they remain responsible. That's a fair statement of the law, Your Honor. He said that in his view, intoxication was not exculpatory. He repeated that idea. No one asked him to address any kind of idea that the mental impairment could be viewed in combination with the intoxication. He wasn't asked that. He did not address that. The defendant was essentially invited to address it prior to Dr. Murphy's testimony when the judge said, well, that's something you can explore in cross, but he didn't. He chose not to do so. To the extent that Dr. Murphy's testimony was not a complete recitation of the law on criminal responsibility, it was not presented as such, it was not expected to be such, and the judge...
And this was on cross-examination. Would you agree that on direct examination, his explanation was consistent with our law?
I would agree that that's absolutely true, Your Honor. He said basically, essentially, that he did not see that any manifestation of the mental disease or defect or the tumor in the behavior at the time of the killing. And therefore, any reduction in her ability to conform, he attributed to the alcohol. Beyond that, there was no likelihood that the particulars of Dr. Murphy's opinion somehow controlled the case and affected the verdict here by itself. It was not emphasized by either party. The details of his opinion were not emphasized by either party during the closing argument, and the judge made it quite clear in her written instructions that went to the jury that the law had to be accepted from her and her alone, that experts were witnesses like any others and subject to any kind of weight or credibility assessment like any other witnesses, and that that a mental disease and defect that was intensified, exacerbated, or in combination with with intoxication could lead to criminal responsibility. They had that there in writing in front of them. If they had any question about whether Dr. Murphy's opinion somehow controlled the law, all they needed to do was look at the instructions and see that the instructions left open the possibility that concerned this court in the first Sheila Berry case in Deep Dover. Your Honors, there's no reversible error in Dr. Murphy's opinion. I'm not sure it even ever could be that just because a doctor in his application of his understanding of the law to particular facts that he makes some kind of mistake that could ever be a standard regarding exclusion or effectively be saying that the only opinions that could come in are the ones that are right, absolutely right. Because there's always an argument about whether the expert has appropriately applied his findings to the law in these cases. That's essentially what these disputes are all about. Your Honors, I'd ask you to affirm the verdicts against Sheila Berry.
All right, thank you, sir. We'll take a brief recess.